Today I'm joined by N.S. Nappinai. She's a senior advocate at the Supreme Court of India, and she's also the founder of Cyber Sati. She's one of India's leading voices on cyber law, on cybercrime, digital rights, and data protection. And in today's conversation, we're going to explore India's evolving cyber and data protection landscape, how India's Digital Personal Data Protection Act compares with the EU's version, and what international organizations should understand when they're operating across borders, when they're relying on large Indian technology providers, and how they manage legal and cyber risks. Napanai, welcome to the International Risk Podcast. Whereabouts in the world are you today?
Right now, I'm in Mumbai, but otherwise, I am now mostly based out of Delhi.
Beautiful cities. I love Mumbai and Delhi a lot. So that's a good place to be. So let's jump straight in. And India has become one of the world's most important digital economies. And I think unquestionably, probably the world's largest and most significant technology service hubs. So, as the business environment has really expanded at such a rapid rate, how would you describe the evolution of India's cyber laws and data protection environment over the last decade as the business environment has raced ahead?
Well, see, the last part of your question spoke about the last decade, but India's foray into cyber law started with the year 2000. And a little bit of background, which many may not know, it actually started a few years prior to that. And the first thing that India contemplated was, in fact, a data protection law, especially after UK had come out with its 1995 data directive, and UK had also come out with its data protection laws in 1998. Thereafter, because of India's commitment to WTO, we needed to come out with a cyber law enactment in line with the model laws that the UN had come out with. And therefore, initially, the thought was to come out with an e commerce law. But what we landed with finally in 2000 was the a kind of semi-comprehensive Information Technology Act, which was then amended in 2008 after the sad, incident of the terror attack in Mumbai, where they realized that we did not have a strong cyber security foundation in terms of law. From there to now, if you look at the way things have evolved, we have been going sectoral mostly. The Information Technology Act was supposed to be redone in the form of a Digital India Act, but that was dropped a couple of years back. It's not probably completely dropped. It may still come to the front in some other form, but right now, we have the Information Technology Act, which caters to e commerce. It catered to data protection. But now we have a Personal Digital Data Protection Act, which will be implemented a year from now. It has been passed, but it has not yet come into force. So, till then, we are in kind of like an interregnum phase, but otherwise, you have the IT Act and you have certain sectoral regulations and provisions which have been driving the cyber law domain.
Yeah, I think that's a really good point. And I think what you covered in your book about that topic was really interesting and very well said. And I think for organizations and business leaders that haven't read your book, for those that are trying to understand India's Digital Personal Data Protection Act, what are the most important things? Like if we talk about the top three or four things that business leaders that are operating in Europe and North America, what do they need to understand about India's DPDPA?
So, what you have is the principles of GDPR having been captured in a very, very short enactment, which the government says is more like the skeletal body of a personal data protection law, which it's going to fill out with rules and regulations. So, the good news for you is that you have a very simple law, but the bad news is that your that law is going to go through a kind of addition, and that means that it is not as glacial as a parliament enacted law. It can go through changes very rapidly. The second thing is, you do not have to worry that India has given you a more rigid law than GDPR. Like GDPR, the DPDP Act also goes on consent plus accountability framework. So you do have certain waivers for consent, but you are still accountable to follow the data principles of, purpose limitation, protecting the data sufficiently, the principles that govern how you will share that data, how you'll utilize it, how long you'll retain it, when do you have to delete it, whom can you share it with, including trans-border sharing. So you have all this captured in that pretty skeletal draft, or I would say minimalist draft. So you need to broadly follow GDPR. You may be mostly in line with what you're going to see in the Indian scenario.
And that's what I wonder, because sometimes when comparing laws between one jurisdiction and another, it doesn't work, and it's not fair because there's other supporting laws or parental laws or social conditions or business practices that just make it not fair. But of course, when India is now, and I think it's fair to say, the center of IT outsourcing, how you compare India's laws like the DPDPA with the Europe's GDPR and relevant laws, you know, we probably should be able to compare and we should be able to confirm. And in fact, I think many European countries require their companies that if they are outsourcing to India, they have to make sure they're meeting the same requirements. Where do you see challenges there? Where are the biggest differences in approach, and where can companies potentially come unstuck?
So India is still not part of the approved nation list of European Union. So the chances of your EU data coming to India is still bleak, except through other means in terms of contractual compliances or third party sharing, etc. But it's very, very strict when it comes to EU data. They are very strict, except when it comes to their very relaxed or lenient mode for USA. So for India, the concern is going to be this: we needed a Data Protection Act couple of decades back or more. We have a minimalist law that has been passed but not yet implemented. And as it stands today, one of the things that Indian businesses wanted was this possibility of India also finding its way into the approved nations list. Right now, that seems a little bleak. Maybe after the rules and regulations come out, EU may review its stand, but right now it doesn't look very positive. But keeping aside the EU data, but let's just talk about cross border data flow into India. You rightly said that India has become the hub for technology services. I would actually venture on to say, unlike its earlier avatar, when it was predominantly a service provider, India has evolved now to uh, developing products. There are so many startups which are so keen on launching their products. And this is my cautionary tale, whether you're an Indian company or an international one. Often they think launch first, ask for forgiveness later. Launch first and ask for permissions later. Under the DPDP Act, the fines are very stringent. The provisions are fairly strict, though minimalist. So you may want to pause before you rush to launch. Remember that forgiveness or permissions may come at a very steep price. You can be fined fairly high, and therefore, that's my caution to any developer who wants to use data as the fuel but may not want a very heavy compliance framework.
How do companies get by this? So you said, the European Union and India's laws are not yet perfectly aligned, but there must be some alignment because there are so many companies. I mean, I work with most of Europe's largest companies on their risk management and their crisis preparedness and their outsourcing and their third party risk, and I know there is a huge number, a large majority that are outsourcing. How do you think? And I'm often asked this question about how do we be compliant?
Often this is actually done through contractual processes. Take HIPAA, for instance, of USA. When HIPAA came out, India did not have even its 43A, which came in through the 2008 amendments. And even the 2008 amendments were implemented only in October 2009. So, how did USA's data come to India then? The companies which would accept the work with respect to data processing or data analytics would have to contractually bind themselves over to complying with the HIPAA provisions. So, to a large extent, contract comes into play where law may not provide sufficiently. But even in those circumstances, when it comes to GDPR, it does not allow for circumvention of the stringent provisions in terms of transfer of data when it comes to EU citizens' data. So then you may be an Indian service provider, but you may be providing your services within the EU. So companies have been structuring themselves in such a way that where there is an impediment, they find a way to get the jurisdiction sufficiently modified to suit the purposes. One of my classic examples I always give is of cloud computing, right? You know the Microsoft case and why it happened in the US because uh, many of the social media platforms claim to be based in USA, and here it was Microsoft service provider. But when it came to data, they said, sorry, we now are in Ireland and therefore it's beyond your jurisdiction. And therefore, USA came out with its Cloud Act. Companies with their footprints in multiple jurisdictions invariably find it a bit difficult in terms of compliance. So, what they do is they also create their own setups uh, by which they ensure that geographically their compliance is valid.
And you talked about that cat and mouse that sometimes regulators and corporate actors play. But for those actors that are concerned about the practicalities, and this isn't just with India, this is in many countries. Now, for some countries, it's very clear. No European or North American company is going to outsource their IT to Russia. They're not going to outsource it to North Korea, to Iran, to China. There's very clear concerns about those. Whereas India, I think companies just have genuine, it's an unknown. They think it's fine, but they're not quite sure. So how should organizations who are asking those questions about, okay, so there's laws, we're working through them, we've got contractual terms, our SLAs, our service level agreements and the appendixes, have certain provisions to protect our data, but we're still a bit unsure about government access. We're still a bit unsure about law enforcement powers. We're still unsure about national security exemptions. How should companies think about this when they're looking at India specifically?
So, today, if you're looking at data and the various products or services around it, any jurisdiction will have to look at multiple issues. One, what is the law of the land of whose the citizens of the citizens whose data they are trying to transfer? Are they transferring the data or merely availing of services? And where are those services going to be provided from? What are all the laws that will become applicable, and how strong or weak are those laws? Sometimes companies want weak laws. Let's not forget that. I told you already, many companies may not want a strong compliance regime too. So they try to do it. It's classic for companies to call it a trade off. What am I trading off when I choose a particular jurisdiction or a particular company which I want to engage with? And how strong are their agreements or contractual terms to protect the company that is availing of services? And finally, remember, the strength of your agreement only lies in the strong implementation thereof. So if you have a very strong agreement, but the jurisdiction you have chosen is very, very weak in terms of its enforcement of the contract, then a strong contract is of no consequence. Similarly, many companies resort to standard form contracts. That still doesn't help you if you make it one sided or unconscionable. So, there are a lot of nuances when it comes to the legal aspects.
I couldn't agree more. I think your point about implementation is critical. Now, I spend a lot of time looking at contractual law and giving clients advice around that. But you're right. At the end of the day, it's what's implemented that actually really, really matters. You need the contracts to prevent, and hopefully, if there's an accident, to remediate or to negotiate or to get some sort of compensation or to fix it. But ultimately, it's that implementation that's just so critical. But I will just take just a short moment, Napanai, to remind our listeners that if you prefer to watch your podcasts, the International Risk Podcast is always available on YouTube. So please go to YouTube and search for the International Risk Podcast. And please do like, share, and continue to subscribe to our content. It really is so important for our success. Now, Nap and I, you talked a lot about a few different topics then, and I think that's really important because, as we've made very clear, India is a major outsourcing. It is a major IT services destination. So, talk to us. Put on your sales hat from a legal, from a cyber risk perspective. What makes India so attractive? Why has it become such a hub? But then also, maybe, can you let us know what makes it cautious? What should foreign companies be cautious about when they're outsourcing IT services to India?
Well, the capability of our technology, experts is mind-boggling. These are young kids who are capable of something which we cannot even fathom. So I think that's actually one of the reasons why India has seen such a big boom of startups. Today's kids have such a huge risk appetite and the capability to back that risk appetite. And so they're happy to go out there, venture, and find out their footing. So I think the technology capability is actually the biggest draw when companies are looking towards India. I don't think law can be the first reason. That's just the supporting actor there. We come in only when trouble starts. Even when you're drafting a contract, you never look at law as the primary actor. We are just a supporting player. Only when things reach a difficult state, that's when law steps in. But in this instance, I would strongly advise companies to look at law also as a primary actor. I used to do this session, called litigating IT contracts, catch them early or watch them grow. That was the caption I had given it. And I always used to address it on three grounds. The first is technology, second is commercials, and third is legal. So each of the teams work separately. But most times they have to work together to understand how commercials can be bound over to milestones in terms of technology. And technology has to be delivered with a keen eye on law. We spoke about the DPDPA Act. Let me just point out that intellectual property rights also play a key role. Many times, companies ignore the necessity for legally acquired or licensed software or tools to be utilized even in the building of their product. And then, when some third party claim arises, an indemnity alone is not going to protect you because your business is going to be affected. So, that's why marrying all three, going hand in hand in a very consensus meeting. I know it sounds utopian, but believe me, it's feasible. And something to that effect of working together is likely to help them more.
Unquestionably, working together in that matrix organization way, or just bringing people together, is smart. But I also love what you said about catching it small or watch it grow is just so important. Is so important because it does. Problems never get smaller by themselves. They only go in one direction, and it's bigger. And so I wonder, and I agree with you that legal protection is there if something goes wrong. Ideally, it also gives us the framework for resolution and hopefully even the framework to avoid there being problems by making clear on roles and responsibilities and remediation efforts. Um, and in that vein, I wonder if we're talking to European or North American, and if we look at financial institutions, those that have the most heavy regulation, and I think we've seen, particularly since 2008 and the financial crisis, the financial institutions generally, from a risk management point of view and from a legal point of view, are the most robust and heavily regulated industries out there. So I think it's a great example. So if we're looking, and we know that some banks in Europe and some financial institutions and insurance companies are outsourcing a significant portion of their data management, their IT services to India, what are some of the legal and contractual protections that they should insist on?
There is one issue we have not really touched upon so far, so let me focus on that. You mentioned in your earlier question also about cyber risk. So, when we talk about financial institutions, cyber risk, protection against cyber crimes, cyber insurance, all of these come into play. So, if you look at India, sectoral provisions for cybersecurity are strongest when it comes to financial sector. And yet, and I know in one of my writings, and I love this, I used Edwin Muir's poem of the wicked gate. You may have the strongest fortress, but that one small wicket gate is enough for somebody to breach your fortress, right? The Trojan horse syndrome. So, cyber risk is something that companies need to be very careful about. What is the buttressing that a vendor or a supplier is giving to you? How well are you protected in terms of not just cyber risk whilst developing the product, but when it's deployed? What are the laws that are going to be applicable to that, and how safe are you? And particularly because, if you look at some of the oldest cyber crimes, it started with very simple siphoning of funds through bank accounts by a bug placed by a software vendor, in a bank. So we have seen cases like that from many decades back. We understand that today the financial sector is much more robust, it's very sophisticated, and therefore the cyber crimes that impact it are equally sophisticated. So we have to keep evolving our remedies and keep a very, very sharp eye out for this.
Yeah, I think that's a really good point that the more robust many of our organizations are, and that's something to be commended and something we should be celebrating. But we can't think that the adversaries, whether they're foreign state actors, whether they're criminal organizations, they're also evolving. And the organizations that are most valuable to them, they're certainly putting in the effort to work out how to work around and mitigate our strengthening and preparedness and risk mitigation actions. Now, you work, of course, in the courts, and you've been doing so for a long time, and you've got a great experience in India. But looking broadly across the variety of different cyber crimes that you see, and I know your organization, Cyber Sati, looks at this, everything from revenge porn to cyber extortion, fake news, and a variety of others. Can you tell us, how should companies be thinking and understanding cybercrime trends in India today, especially when we think about fraud, identity theft, social engineering, ransomware, business email compromise? What should business leaders understand about the environment in India today?
One of the biggest financial frauds that are happening and which has impacted foreign companies, and I've come across too many of these, are in terms of the email frauds or the impersonation frauds. So, a company A, which is based, let's say, out of USA, has engaged with a supplier in India, and the supplier raises a bill, and company A pays the bill, and then finds out it wasn't actually their supplier. It was a man in the middle who has actually hacked into the supplier systems, found out these details, and then payment has been routed out. And I've come across very interesting cases where a person falls prey to an impersonation attack. Then they are informed that it is impersonation and that you should be careful. And then they are made to pay again. Even that is actually to the same fraudster. You would be amazed at how gullible and very easily they can fall prey. In fact, India is right now, the Supreme Court of India, in fact, has taken so much of cognizance of the most prevalent and very, very sad case of digital arrest that's happening now. And I'm a amicus curiae in that case, in fact. And one of the things that may impact foreign vendors is that since bank accounts are misused, for siphoning out the monies, one of the processes that has been implemented is freezing of accounts. So, if your money is stuck in an account which has been misused, then your money is frozen there and it will be applied to first the proceeds of crime to reimburse the victims and only thereafter to recover your monies. So, who you deal with, how it works, and how secure, as well as the money is critical.
How much do you see AI really driving the whether it's the digital extraction, the fraud, the online harm in India?
A lot. In fact, Cybersati is a non-profit. Thank you for bringing that to the fore. And what we try to do through Cybersati, and as part of that awareness program, I wrote my second standalone book too, and I called it, to meet the requirement of Gen Z now, Sassy Tales, Cybercrime Stories and the Law. And the whole idea of Sassy Tales was to explain how these kind of frauds happen. So initially, we called it the grandparent scam, and I've covered that in the book too. Grandparent scams used to happen through a text where the grandchild is asking for money and says, "Please don't tell my parents." And then, I've been arrested, or the police are threatening me, I have to pay off, or something like that. And the grandparent sends money and then finds out it was not the grandchild. You have people impersonating police officers, impersonating judges. So AI has been used and deepfakes have been used extensively, from job scams to these grandparent scams to digital arrest cases. AI is like the most favored tool of the criminal right now. And therefore, having strong AI laws is actually a criticality which India still does not have.
And maybe just very briefly, when you look ahead, what are the developments in India's cyber laws, in protection, AI regulation, digital governance? What do you see changing? Do you see any changes? I understand the laws are evolving and improving and then strengthening. What are the things that we should be looking at when we're looking at India's legislative landscape?
The first word of caution, and this is actually more for the Indian legislatures, is they need to approach law with the multi-pronged approach. It cannot be a knee-jerk reaction. So don't substitute paranoia for caution, because laws should be an enabler and they should not end up stifling innovation. So we spoke a lot about AI and its misuse. Merely because a technology can be misused does not mean you're just going to say off with their head, right? You still need to use the technology. You have to gain from it. You have to benefit. The economy has to benefit from it. So I see this positive trend in India where the ministries have started looking at laws as an enabler too, and not just for prevention, protection, and punitive action. So when we talk about it as an enabler, it's critical that laws are very precise and clear and transparent, and there has to be certainty. Yes, technology is evolving faster, so governments are also opting for delegated legislation, but that should not be overdone, because then the certainty part of law requirement. The Digital India Act was one such initiative where it appeared that they may get a comprehensive law in place, but that has not seen the light of day. The way I look at it from an Indian scenario is, one, I definitely see something new coming in place of the Information Technology Act, having simpler but more robust provisions for regulating e commerce, social media platforms, and all the other digital processes that are happening. And most critically, I feel that India needs a cybersecurity law, and that cybersecurity law needs to provide for emerging technologies. Today, as I mentioned earlier, sectoral laws are providing for emerging technology regulations. Cybercrime law needs to be more robust, but ultimately, the problem we see in India, and I repeat myself when I say this, is in the context of implementation. A law is only as strong as its enforcement. So, if a law is looked at as a paper tiger, then nobody is going to really pay attention to it or abide by it. So, I feel India needs to strengthen its implementation processes, and very soon.
No, that's excellent. And one final question in our last 30 seconds that I ask all guests on the International Risk podcast is, when you look all around the world and you're looking at all the international risks that we have, from the environment to war to financial stresses, what are the international risks that concern you the most?
International cooperation. I was part of the UN's Cybercrime Convention. We saw so much of cooperation when initial talks started. And when it came to signing, however, the countries which had even participated strongly in the negotiations refused to sign, right? So I think when it comes to the digital domain, You cannot substitute international cooperation.
Yeah, I think that's a great one on so many levels, whether it is on finance, the environment, geopolitical tensions. I think more international cooperation is certainly needed. Well, thank you for highlighting that. And thank you very much for coming on the International Risk Podcast.
Thank you. I enjoyed this journey and look forward to more. All the best to you for this.
Thank you so much. Well, that was a great conversation with NS Nappinai. She's a senior advocate at the Supreme Court of India and founder of Cyber Sati. I really enjoyed our conversation today around cyber laws, cyber crime, digital rights, and data protection in India. And I think this is an important conversation for all of us, those working internationally, and of course, those outsourcing and working in India. I'm Dominic Bowen, host of the International Risk Podcast. Thanks very much for listening. We'll speak again in the next couple of days.